The business card landed on my grandmother's kitchen table 3 days after we buried her. Not a condolence card, not flowers, not even a phone call before they drove 4 hours from Phoenix to stand in her house like they were taking inventory. My uncle set it down between the casserole dishes people had brought over, slid it toward me with 2 fingers, and said, "You'll want to call that number before you make any decisions about the property." The card belonged to a real estate attorney. My uncle didn't look sorry about the timing. He looked like a man who'd been waiting for permission to stop pretending. My grandmother Nana had raised me from age 9, after my mother's accident. Not temporarily, not as a favor. She enrolled me in school, came to every parent-teacher conference, and made me do my homework at the kitchen table every night until I left for college. Her house in Tucson was where I came back for holidays, where I kept a box of things I couldn't fit in an apartment, where I called from the road when I was scared or tired or just needed someone who answered on the first ring. When she got sick 3 years ago, I was the one who moved her medical appointments into a calendar app and showed up to everyone. I was the one who coordinated with her doctor after the first fall, who had the grab bars installed in the bathroom, who sorted her medications into the weekly pill organizer every Sunday. My uncle lived in Phoenix. He had a boat. He visited at Christmas if the weather was good. Nana died on a Tuesday in early November, quietly, which was how she did most things. The will was straightforward. She had a small savings account, the house, and a car that still ran but had nearly 200,000 miles on it. The house was left to me outright in a recorded deed she had signed and filed 18 months before she died. Not buried in a will where it could be contested, but a transfer on death deed, documented and registered. Her attorney had walked her through it. My uncle knew this. He had to know, because Nana had told me she told him. What I didn't know was how he'd spent the weeks between hearing that and the moment he sat across from me in her kitchen. "What decisions?" I asked. He folded his hands on the table. Reasonable posture, reasonable voice. He'd been practicing. "The house needs work. You're not in a position to maintain it alone, and frankly, selling makes more sense for everyone." I looked at him. "For everyone. For the family," he said. "Nana would have wanted." "Don't," I said. He blinked. "Don't tell me what Nana would have wanted. You weren't here." His wife was in the living room, not looking for something cabinet-specific, just looking. My uncle set both palms flat on the table, deliberate, like a man who'd watched too many negotiation seminars. "I've had an attorney look at the estate. There are questions about the transfer, whether she was fully competent when she signed." There it was. Not grief, not family, competency. I had sat with Nana through every appointment for 3 years. I had heard her correct her own doctor on medication interactions. I had watched her beat me at Scrabble 11 days before she died. The woman was sharp until the last week, and even then, she knew exactly who was in the room. "The deed was filed 18 months ago," I said, with her attorney present. She passed her cognitive screening 4 months after that. "Those things can be challenged." I stood up. "You should go." He didn't move. "We're not trying to make this hostile. You brought a real estate attorney's card to my grandmother's wake." He had an answer ready. He always did. My uncle was a man who'd built his whole life on having an answer ready, so he never had to sit with the fact that the answer was wrong. He said Nana hadn't understood the full value of the property. He said she'd been isolated. He said she'd been influenced. That last word sat in there between us. I had given up 2 years of career momentum to manage my grandmother's care. I had driven her to appointments in the rain and coordinated with specialists and handled her insurance appeals and sat in hospital waiting rooms with a laptop so I could still make deadlines. And now the man who'd sent a Hallmark card at Christmas was using the word influenced. "Get out of my house," I said. It was the first time I'd called it that out loud. "Mine." He left. His wife followed, still carrying her coat, like she hadn't quite committed to being there in the first place. The front door closed, and I stood in Nana's kitchen for a long time, not moving. I called my neighbor that night. Dorothea had lived next door to Nana for 22 years and had become one of my closest friends over the 3 years I'd been managing Nana's care. She was also a paralegal, which I'd never thought to take advantage of until right then. I told her what happened. "He used the word influenced," she said. Verbatim. She was quiet for a second. "Do you have a copy of the deed?" "Yes. And the cognitive screening record. Her doctor will have it." "Good," she said. "Do not throw anything away. Do not agree to anything. And get yourself an estate attorney by the end of the week." I took her advice seriously, but I didn't yet understand how seriously I needed to take it. 4 days after the kitchen conversation, I got a letter. Not from my uncle directly, from his attorney. It was written on heavy cream paper in careful legalese, and it accused me of exercising undue influence over an elderly and cognitively vulnerable person to secure a transfer of property that rightfully belonged to the estate and should be distributed among surviving family members. It said my uncle intended to contest the deed. It also said, very politely, that if I wished to avoid lengthy litigation, I might consider entering mediation to discuss a voluntary transfer or sale. I read it twice. Then I called Dorothea. She read it over the phone while I held the receiver. Then she said, "This is intimidation on letterhead, but you still need an attorney." I already had a call in. By Friday, I was sitting across from an estate attorney named Mr. Beckett. Not the same one on the card my uncle had left, but mine. And we went through everything. The deed, the filing date, the cognitive screening. Nana's attorney of record, who was still in practice and who, it turned out, had kept meticulous notes from the day Nana signed. Mr. Beckett looked at the notes and said, "Your grandmother asked questions during the signing, specific ones, about what would happen if the deed were challenged. She wanted it built right." I thought about that on the drive home. She'd known. She'd sat in that attorney's office and thought through exactly what her son would do, and she'd asked the right questions ahead of time. She had always been 3 steps ahead of everyone in the room. I just hadn't realized she'd applied that to this. 2 weeks after the letter, my uncle escalated. He filed a formal probate petition to challenge the deed on grounds of undue influence and lack of capacity. His attorney submitted an affidavit from a neighbor of Nana's, not Dorothea, but someone I barely recognized, an elderly man who lived 2 streets over, and apparently told them Nana had seemed confused the year before she died. Mr. Beckett read me the affidavit over the phone. When he finished, I said, "She won 3 Scrabble games in 1 week that year? Do you have documentation?" "I have the score sheet." "She kept them." He paused. "Get it? It sounds absurd. Scrabble scores as legal evidence, but what it proved was simple. Someone who's cognitively impaired doesn't maintain a running score sheet over multiple weeks, annotate it, circle her highest point words, and leave it in a labeled folder in her filing cabinet. Nana's filing cabinet was a small masterpiece of organization. Everything labeled, everything dated. That cabinet turned out to be important. Dorothea had helped me sort through it the week after the funeral. We'd found, behind the household folders, utilities, insurance, medical, a folder labeled simply House. Inside was a copy of the deed, a copy of the filing confirmation, a printed summary of Nana's estate planning consultation, and a sealed envelope with my name on it in her handwriting. I hadn't opened it yet. I didn't know why. Grief has its own timeline. I opened it the night before the first court hearing. It was 2 pages in her handwriting, which was still careful and looped even near the end. She wrote that she had thought for a long time about how to protect the house. She wrote that she knew her son and that she loved him anyway, which was something you could do, love someone, and still understand exactly what they were capable of. She wrote that she had spoken to her attorney specifically about challenges and had asked him to keep detailed notes because she anticipated exactly this. She wrote that if I was reading the letter, it meant she was gone, and that things had probably gotten complicated, and that I should not feel guilty about any of it. She ended with, "The house was yours," before I put it in writing. I was just making it official. I sat at her kitchen table for a long time after that. The hearing was preliminary. My attorney presented the deed, the filing record, the cognitive screening results, and the notes from Nana's estate attorney documenting her questions, her competency, and her explicit intent. My uncle's attorney presented the neighbor's affidavit and a statement my uncle had written himself about Nana's health. The judge didn't rule that day, but she asked my uncle's attorney a specific question. What evidence did he have that the decedent lacked capacity at the time the deed was signed? Not generally, not in her final weeks, but specifically on that date 18 months before her death. The attorney said they were still gathering evidence. The judge said she'd need that evidence before the next hearing. Outside the courthouse, my uncle found me in the parking lot. He walked over like a man who still believed proximity would get him somewhere. "This is going to drag on for a year," he said. "You know that. That's your choice." He looked at me the way he always had, like I was someone who didn't quite understand how the adult world functioned. Like I was still 9 years old at his mother's kitchen table and he was waiting for me to get out of the way. "We're family," he said. "Family takes care of each other." "You mean family shares," I said, even when the will says otherwise. He started to say something else, but I was already walking. His wife called me that evening, not to apologize, to explain. There was a difference. She wanted me to understand that this wasn't personal, that they simply felt Nana hadn't been herself at the end, and that a fair resolution would benefit everyone. I listened until she ran out of new ways to say the same thing. Then I told her I was represented by counsel and asked her not to contact me directly. The next morning, Dorothea came over for coffee, and we went through the house again, not looking for anything specific, just being in it. Nana's dishes were still in the cabinet. Her reading glasses were on the side table by the armchair. There's a particular kind of grief that lives in small objects, and I hadn't touched most of them yet. Dorothea found the second folder. It was in the back of the cabinet behind the one labeled house, in a plain hanging folder with no label at all. Inside were printed emails, 3 years worth of them, between Nana and her attorney. And 4 months after she signed the deed, Nana had written to him asking what happened if someone claimed she'd been influenced. The attorney wrote back. His responses included a specific line: "I would recommend we document your ongoing capacity through regular notations. I'll keep a file." They had exchanged emails every few months since then, updates on her health, her own notes on her cognitive state, dictated to the attorney, records of her decisions and the reasoning behind them. My uncle's attorney had demanded the estate attorney's files in discovery. He had received them. But based on how the hearing had gone, I wasn't sure he'd actually read past the first page. I called Mr. Beckett and told him about the emails. He was quiet for a moment. Then he said, "How far back do they go?" "All the way to the month after she signed the deed." Another pause. She built a record. She built a record, I said. At the second hearing, Mr. Beckett introduced the email correspondence as a supplemental exhibit. The attorney for my uncle objected on various grounds. The judge overruled each one and read through the first 2 pages herself in the courtroom, which I had not expected, and which seemed to surprise my uncle's attorney considerably. The judge asked my uncle directly whether he had been in contact with his mother in the months after the deed was signed. He said he had. She asked whether, in those conversations, she had seemed confused or incompetent to him. He hesitated long enough that the hesitation became its own answer. The judge set the hearing date for final ruling and said she'd heard enough to form a preliminary view, which she would not share from the bench, but which, she noted, the parties ought to consider before spending further resources on litigation. My uncle's attorney requested a recess. They came back 20 minutes later and asked whether I would be open to a settlement conversation. Not about the house. They'd abandoned that angle. About legal fees. I looked at Mr. Beckett. He looked at me. I said no. They asked again differently, using softer language. I said no again. The judge issued her ruling 6 days later. She found no credible evidence of undue influence. She found ample documentation of my grandmother's competency at the time of signing and in the months and years following. She dismissed the petition with prejudice, which meant my uncle could not refile the same claim. The deed stood. The house was mine. I was sitting at Nana's kitchen table when Mr. Beckett called with the ruling. I had a cup of coffee in front of me that had gone cold. Outside the window, the yard was the way it always was in November, dry and still and very Tucson. I thanked him and said goodbye and sat there for a while. My uncle sent one text. It said, "I hope you're satisfied." I didn't answer. His wife sent a longer message, several paragraphs about family and grief, and how she hoped we could someday repair things. I read it once and set the phone down. There are some bridges that don't need repairing. Some of them were in bad shape long before anyone thought to light them. What I kept coming back to in the days after the ruling was the folder with no label. Nana hadn't told me about it. She hadn't left a note pointing to it. She had just put it there in the back of the cabinet behind the labeled one because she was organized and she was careful and she had thought it through the same way she thought everything through. She had watched her son for 7 decades and she had made her decisions accordingly. I changed the locks the week after she died, not because anyone had a key, but because it felt right, because it was the first decision I made about the house as mine, and that mattered in a way I couldn't entirely explain. I kept the Scrabble score sheet. It's in the filing cabinet now, in a folder I labeled in my own handwriting. I'm not sure what category it belongs in. I put it under N for Nana, which felt right. The house needed the front walkway repaired, and the HVAC serviced and the kitchen faucet replaced. I did all of it over the next 2 months. I kept her reading glasses on the side table. I kept her dishes in the cabinet. I moved slowly through the things that were hers, not because I was avoiding it, but because there was no deadline anymore. No one was coming to take inventory. She had made sure of that. If you made it this far, I'd like to know what you would have done when that business card landed on the table. Would you have called the number? And which moment hit you hardest? The letter about competency, the judge's question in the courtroom, or the folder with no label in the back of the filing cabinet. If this story meant something to you, leave a like and stay with me for what comes next.